I know that you've said that you've secured 45 convictions between January and July when the court went on vacation, but the truth is that more Nigerians would like to see convictions or even acquittals, as the case may be. Some people think that the corruption cases filed by EFCC are handled by a few lawyers, that this maybe has contributed to the delay that we see with the cases leading to a conclusion.
You must understand that the criminal justice system involves not just one actor, not just the prosecutor, which EFCC represents. You have the defense counsel, you have the prison system, then you have the courts, then even the accused person himself. Then you have the procedural laws that guides these things. You are saying EFCC, yes, people want to see a lot of whatever. Let's take one of the topical cases going on, that of the current Senate president. We are all aware of the way the case had to go from the Code of Conduct Tribunal to initially a federal court, issues of fundamental rights and whatever, then to the Court of Appeal, to the Supreme Court and back. So at that level, will you attribute it to the prosecuting agencies? So these are some of the dynamics involved that may not allow, in quotes, speedy prosecution the way Nigerians want it. The accused person on trial too has a right. He has the right to be given time, as enshrined in the Constitution, time and facilities for his defense. If you want to move at the speed of a supersonic jet, and the defense counsel says, oh, with this burgeoning proof of evidence that you have brought, I want time to be able to study, there's nothing you could do. If he files the application before the court, irrespective of the new Administration of Criminal Justice Act, the judge still has to make one pronouncement or the other. All this would, if he says, oh, a statement which he voluntarily made while he was with you, when he gets to court and says it was involuntarily made,
made under duress.
Yeah, a trial within trial will be conducted, meaning that the substantive trial is aborted. Yes. We concentrate on that, witnesses, evidence, and everything. You can imagine the period that will be spent on that. We understand the aspirations, we understand the agitations of Nigeria, that this is what they want. We will try within the constraint of the system, and we are even trying to give them the very best of what we can do within the constraint of where we are.
But with the layers that are in place to vet charges, have we seen an end to 100 counts, 110 counts, all the lengthy charges that we sometimes see with EFCC cases? Okay,
fine. You see, what people don't seem to appreciate, there is a simple logic or principle in criminal procedure. It's called that every single transaction forms a separate count or charge. I'll give you a typical example. You have somebody who is a 419. He assumes the identity that, look, I'm the owner of a property consisting of several blocks of flats somewhere in Victoria Island. And he now makes an advert calling for prospective tenants. In the process, collected money running into maybe between 5 million and 10 million and whatever from about hundreds of people. If you were to charge that kind of person, there are several victims to court. And this thing runs over a trend of period. It's not just a particular year. Would you say that because, oh, you do not want counts to be lengthy, that some victims should be abandoned and not incorporated into the thing? Nobody, do you know what it takes to draft all these things you call multifarious counts? We understand the basic principles of criminal procedure, that each count that you draft has to be proven before the court. It's there. We are lawyers too. I was called in 91. Under the provisions of the Constitution, within the number of years you have to be appointed a justice of the Supreme Court. Ordinarily, one is qualified. one is qualified to be at the Court of Appeal. So it's not that those you see at the legal department themselves are not trained as lawyers. They understand what they are doing.
Let's talk about plea bargain. We've heard that some defendants are returning assets and they've elected to enter into a plea bargain arrangement. Can you tell us presently what percentage of cases are being plea bargain, and how does the agency work out that arrangement so that Nigerians are not shortchanged?
Let's move from this aspect. The first thing you need to understand is there is so much ignorance being exhibited out there about plea bargaining. People need to be educated about it. By entering into plea bargaining does not mean the person is going to go scot-free. That's point one. Point two, they need to understand is that even plea bargaining has become statutory in Nigeria. The Administration of Criminal Justice Act recognizes plea bargaining. The Administration of Criminal Justice Law of Lagos State, Section 75 and 76, recognizes plea bargaining. And soon, the Administration of Criminal Justice Act will be domesticated by several states. So plea bargaining has now become statutory. So it is not something being practiced by EFCC willy-nilly. Then even in developed countries, research has showed in the country we all like to refer to as example, United States of America, 95% of their cases is done through plea bargaining. That shows you the usefulness of that option in criminal prosecution. In the EFCC here, there is a policy. What we are dealing with is not just an ordinary crime, it's an economic and financial crime. And if you look at Section 46 of the EFCC Act, it defines economic and financial crime as the illicit acquisition of wealth. So, at the principle of economic and financial crime is that money which has been taken from the victim. So one of our policies is that before you talk about even plea bargain, restitution is key, because that is the hallmark of economic. This is not armed robbery. This is economic and financial crime. So we will ensure, and that is the principle we follow, that at that point you are making an application, because normally the procedure is that it is the defendant, that's what you call them now, no longer accused person, through their lawyers who apply to the EFCC saying we want to enter into plea bargain in respect of what we are doing. We are not the ones who invite them to come. They are the ones who come voluntarily, having seen the avalanche of approval of evidence that with the way things are going, it's not really worth it for them to go on a full trial. So they write applications to us. We consider that application. We invite their lawyers to come in. And the first thing we tell them, this is the amount of money involved. This is what investigation has been able to. You must pay this money before we even talk about anything. And at the end of the day, we recognize one thing. Sentencing under the law is at the discretion of the court. So most plea bargain agreements we enter into is there, that your lordship have the discretion to sentence. We have done this and this, we have disgorged him, we have restituted the victim. This is the crime that he has committed. And he has agreed with us to say he will change his plea from not guilty to guilty. Now your lordship is over to your court. Look at your sentencing guidelines. The Federal High Court now has a sentencing guideline. You have sentencing guidelines in the Administration of Criminal Justice Act. Use that now and come to the conclusion as to the amount of sentencing that you believe the accused person or defendant should be subjected to.
The EFCC doesn't advise on what sentence?
Plea bargain is essentially an agreement. You crystallize whatever you do with the accused person in an agreement. We recognize the fact that we are acting for the public. So we will never act contrary to the public interest. Besides, the Administration of Criminal Justice Act has provided criteria which we have to apply in doing plea bargain. Then be mindful of one thing, which people are never aware of. The courts have a right to reject the plea bargain agreement. So there are checks and balances. Then we are again conscious of one thing here, which I want people to realize. Whatever we are doing here, it's a privilege. Other Nigerians could probably do it better than us. We consider it a patriotic duty to ensure that the interests of society, the victim, and then that of the accused is taken into consideration when we are doing these things, and that is what we try to do.